In Chapter 18, it talks about the administrative law, which is a statute or regulation that directly or indirectly affects administrative agencies. The procedural rule and substantive rule administrative agencies is created by the legislative branch to carry out specific duties. Types would be independent, executive, administrative agencies. Creation of administrative agencies. Enabling legislation grants power to an administrative agency to issue rules, investigate violations of rules or statutes, and disputes. Functions of administrative agency would be rulemaking, adjudication of individual cases brought before administrative law judges by agency staff, administrative activities, informal advertising, preparation of reports, insurance of guidelines, and the rulemaking models in the APA would be formal, informal, hybrid, and exempt. 4 steps of adjunction would be investigation and compliant, formal complaint and hearing, recommended decision or appeal in the full commission, federal status. Limiting administrative agencies' authority would be the Administrative Procedure Act, the Federal Tort Act of 1946, the Small Business Regulatory Enforcement Fairness Act of 1966, and the Congressional Review of 1996. The state and local administrative agencies exist to the District of Columbia, Purdue, and Guam, possess utilities commissions, zoning commissions, real estate planning boards, and supervisory boards. In the Supremacy Clause of Article 5 or 6 of the U.S. Constitution plays a significant role in situations where federal and state agency laws conflict. The global dimensions would be the bank regulated by Federal Reserve Boards, the controller of currencies, and state bank regulatories. And security forms regulated by the SEC, State Security Commission, National Association of Security Dealers, and commodity futures regulated by the Commodity Future Trading Commissions. Insurance regulated by the state insurance commissions. In Chapter 19, it talks about the wage and hour laws, the Davis-Bacon Act, which contractors and subcontractors working on government projects are required to pay their prevailing wage. Fair Labor Standard Act covers all employers engaging in interstate commerce or the provision of goods for interstate commerce. Unemployment compensation. The Federal Unemployment Act provides compensation to qualify employees who lost their jobs. State can draw and distribute funds. It does not cover employees fired under a just case and employees who have voluntarily quit, and its eligibility standards differ among states. The COBRA Act of 1985, upon termination of employment, employees continue receiving benefits for themselves or their dependents under the employer's policy. Worker compensation laws provide financial compensation to employees or dependents when employees are injured on the job. The Family and Medical Leave Act of 1993 guarantees that workers facing a medical catastrophe or certain specific family responsibilities will be able to take needed time off from work. The Occupational Safety and Health Act of 1970, designed to make workplace free from recognized hazards that are likely to cause death or serious harm to employees. Employee Privacy Act is Electronic Communications or Privacy Act. Immigration Reform and Control Act of 1986, employees required to hire only legal citizens and authorized non-citizens. It must be verified by Form 19. Immigration law must be green card holder, and the global dimensions are rights of employers in other industrialized countries are far more extensive than the United States.